so glad to see y'all. Oh my gosh, this is awesome. So happy to see everybody over here. Thank you for teleporting. I am in the process of trying to get our interpreter on. If she can come on, we'll see how things are going for her. Someone made a suggestion I do a window in interpreting. I will when I'm officially interpreting, but it does make it very hard for me to do everything that way. I'm working on it. And that's what we're going to go with that. We're going to go that way. While that is, while you're giving me a hard time. Hello, everybody. Hey, little miss. Hello, Trial Junkies United. Hello, everybody in Trial Live. We love and appreciate you and so happy to see you. This is where we are with them right at the moment. We are waiting for them to come on. Oh, come on. Come on about my house. I hate that song, honestly. Kind of do that. I like their warning. I may start doing the same thing. It's important. Hello from Wisconsin. Yeah, when we start when we are actually interpreting, then I'll definitely do that. I am missing my mods. I'm missing my buds. I'm missing everybody. It's awfully quiet. Let me just kind of get this up here and let that function. I'm going to do one more of a refresh on the docket page. Motion to suppress just was put, but we do not have a copy of the documents. So they have 3 more documents that's not here. Hi, Kristen. Hi, Dawn. Adeline. Hi, Dr. Bull Butter. Y'all are awesome. Thank you so much. Thank you. 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 Maybe I should cover her face. No, I won't do that. So I do know that there's 3 more documents that's been put in for a motion to suppress, but it is not showing up. So the request it's pending. I told you they're going to drop more documents. I knew it. What can I say? Let me see if I can get a hold of my interpreter. I know she's got a job and she's working, but I'd like to see if she can hop on for this. It would be great if she could. Let me see if I can get her. I want this sound. Love it. Oh, that's not true, Miss Bill Butter. If you want a mod, well, get a hold of Miss Kevin. Go into our Discord. Ask Miss Kevin. Say, I want a mod. She's our mod boss. Go through her. So I guess I'm going to have to call Margie. Marge, where is your sister? I need your sister. I need her presence. Because this chick is having an optical migraine today. Yeah, I'm keep refreshing this page. Let me tell you. Okay, that ain't happening. Okay, so one of us will do the interpreting. Dr. Bullbutter, if you want a mod, do you have our Discord link? I'm looking to see. Okay. So let me go up here and get my Discord link. And then I'm going to put it here in comments. Join us on Discord. You were in your Discord. Okay. You know how to do a private chat with Miss Kevin? If you can reach out to Miss Kevin, say, I'm interested in modding. And she does all that setting up. just half asleep? What, is the left side asleep and the right side awake? Because that's how I felt this morning. I have not heard from somebody, and I'm getting worried. They're not well. You know what? I've had this unusual cough, and yes, she is Miss Kevin on Discord. She's my mod boss, and that's what I name her, and, I mean, that's exactly what she is. She's our mod boss. So with that, she's fabulous. She does have her hands full at the moment, so if she doesn't answer right away, don't be offended. That's who I'm missing. I may have to call this one. Oh, it should be Miss MRS. Why is it Mr.? Yeah, it's MRS. Do you know that? Did you know that's how parakeets sleep? Half of their brain sleeps while the other half stays awake to watch for predators. Yep, I knew that. Believe it or not, I did. I shock myself sometimes. Yep. Brains are amazing. Brains are amazing. I'm refreshing this like crazy because as soon as the doc gets posted, I want to grab it. So they did enter a motion to suppress. We just don't have it now. I don't understand why my thing is not connecting, although it shows it is. So I got to work on that because that's awesome. I love my StreamYard thing. What the video? Oh, I got to keep that up for homework tonight. My Elgato Stream Deck. So I need to go in and work on that. Let me go over to this one here and see. Okay, just out of, do you hear this? Please tell me you heard that. Did you hear that? Because if y'all heard that, let me know. Amy, how are you? Good. Oh, hello. Got on the train. Doze off with one eye on your wallet. Yep, found you via Broken Baker. Wish I could stay, but I have an appointment 13 minutes. We'll be watching on later. Thank you, Silver Fox 74. I would be 71. Thank you so much for joining. We really, really appreciate you. Okay, so I have different programs for different things, so I guess it didn't work. Okay, I'll just have to go play with it later. Maybe it missed something in the update. What's going on at Elgato corner? Accessory. I'll figure it out. So we are waiting patiently for the trial to start. I want to share this picture. I saw this on Facebook and I was like, yeah, baby, this is me. Open with pictures, photos, expand. And I'm going to show screen. This I want to take and change it up and make this my new logo because I love it. I know some people may not get it, but oh well. I am Irish, Cherokee, Cree. Look at that. I love it. I got to make her fatter though. She's too skinny. How does it go? Like this? Love it. I know, Dawn. I know, Dawn. Dawn, I am freaking heartbroken. that he passed away. It broke my heart. I was in Tennessee last year with my daughter, and we went to their they had in Nashville. I didn't plan this, but I did it. They have a store. And so some of the things that you see them finding ends up in their stores. And oh my gosh, y'all, I had so much fun. I mean, a lot of it was out of my price range, of course, but it was awesome. Learning Cherokee here and there. Okay. Miigwech. Do you know what miigwech is? I don't know what OSDI. OSD? Is that right? OSD? Coffee? Cawdy. I know it's close. But if you hear me say miigwech, that's the highest form. No, that's the highest form of thank you. Miigwech. Say it a lot when I get into my prayer time. Come on, Cameron. Adjust. I'm not that pale. Whew, I'm not that pale. I signed up to take a class to learn Cherokee through the Cherokee Nation, but the guy teaching it had such a harsh speaking accent, and he talked about like this. I couldn't do it. Couldn't understand a word he said. And Cherokee doesn't have ABC alphabet. It's very unique. It's almost like OSDI means how are you? Can you phonetically spell it the way it's supposed to sound when you say it? No, this, yeah. Oh, I need to show y'all this. Y'all want to see how I slept last night? My monkey was with me last night, and this is a Facebook picture, but this is picture of, it's not what's supposed to be showing. What are you doing? No, that's not what I want. That's what I want. This is me back in 2015. Pause. This is me back in 2015. My monkey was, let me begin. If I can. Well, I guess I can't. There we go. My monkey was born in 2015. This is October, so she was about 3 to 4 months old here. That's my baby girl. Yeah. You do? How do you have that, love? Hi, Scooter Foodie. I know. I'm watching. I'm refreshing like every 30 seconds. This is her with me when I was sleeping last night. Yes, I had a nightgown on, doing those real skinny tank top type things. But she was loving all over her mamas. I know, guys. Not the best picture of me, but somebody asked about my monkey. So I thought I'd just oblige. Oh, I know. I've got it right here. This whole screen is nothing but the Orange County courthouse records, and it dropped. Amy, in chat, can you tell me how do I get that keyboard? How? I want it. Yeah, see, this is how their stuff is. It's like that. Her name is Nala. Nolly. We sometimes call her Nolly. Affectionately is Nolly. So, yeah, she sleeps with my son a lot, but now that because she used to sleep with me all the time, and then I got my service dog, and she's now to the point to where we can be in the bed with her and the service dog as long as the dog isn't moving a whole lot. She's fine. She just didn't want to sleep there last night, and I was like, "Gotta sleep." She's like, and when she talks, it's oh, oh. that kind of stuff. She's full grown now. She's full grown. How do I find it? Oh, this coffee is good, y'all. Either my taste buds have changed or this is just a well, I have a different I'm using a stronger flavor. I just refreshed. They still have not released the pages. I wouldn't be surprised if they did not release those pages until after the hearing. Y'all, we got 5 minutes left. 5 minutes left. I'm excited. Come on, share the post, please. If you've not been here before and you have not subscribed already, put I subbed in to get 1 entry. And if you become a member, you get 10 additional entries for the maximum of 11 because I'll be giving away a Halloween's tumbler. Now, this was one I got for last fall, but the one I hope to get for y'all are going to be cool and decorated. If you don't like it, we can try and find a color that you like and I'll get that. But yeah, baby. This is what's going to be given away. I'm trying to reach 3,100 subscribes by the 31st of October. Right now, where are we at? Let me pull it up and see where we're at. What was that? Did you know John Amos' cause of death was revealed, but his child didn't even know he died? She found out on social media. Y'all, I think that is so wrong when people find out about their loved ones on social media. I just think that is absolutely hideous. That's why when I'm on scene, I don't let people post anything. Okay, guys, we're moving. We're at now 2,264 subscribers. Wow. And memberships, what's our number? Oh, we've dropped considerably. Wow. Well, we've had a lot that were sponsored. So is what it is. But I want to say thank you. Oh, a lot of you've changed colors. Yay, we've got some 2-monthers. We've only been having memberships for 2 months. And our first member, I think was it I can't remember, was it Paula? It was our first? Oh my gosh, I can't remember. Wow. Wow, y'all are awesome. I hadn't looked at these numbers. So thank you so much, everybody who's become a member. I am so ecstatic over this. We will be having our members only live this Saturday night. I mean, sorry, Sunday night. Used to be Sunday night. We'll be having our members only live. Language, Windows 10. Okay. I will do that because I have somebody that I know that speaks and reads it, and she's an old lady, and I'd love to send something simple. Ronnie, yay! We're waiting. I'm killing time. We have a bunch of things that were filed today, but all they were was basically them stating that they acknowledged that they received information from the other side. So nothing major. And then just about 15 minutes ago, they have a motion that was posted. However, the documents were not posted. So let's see if they, oh, they're up. They're up. I got them. I got them. Oh my God, let's do this. I can't believe I did it. We're so good. We're so good. Oh, I'm doing the wrong thing. Here we go, y'all. Yeah, we're all ready to hear this, Miss. I'm a little kind of on a fake caffeine high right now. I apologize for that. Nothing I can do about it. What happens when you wake up and Everything just goes swimmingly. Okay, here we go. I'm gonna move it over here so I can see. Oh, I got a message notification. I gotta check on my friend. Y'all, it's my mother. Let me sorry. My adopted mom that raised me, who I call mom, um, got a hold of very rarely does she call during the day, so I just wanted to make sure she was healthy and okay. Alright, real quick, while we're waiting for this saga to begin, let's look at this. I can't believe we're getting this so quickly. The defendant's second amended a motion to suppress defendant's statements at OSCSO. So they're coming forward, they want to suppress. On September 30th, the 24 defendant filed an amended motion to suppress statement at OCSO. Orange County Sheriff's Office. The defendant reiterates the facts and arguments as outlined. The arguments are both the United States and Florida. I don't want to get into that. Um, why is it doing that? Okay, I got to find a better way to do this, but right now this is all I got. Let's see what we have. Okay, so we're gonna go to the next page. While the defendant may have waived um, effectuation of their what? Excuse me. I got a cat hair on my face. Rights such as a waiver may be made voluntarily, knowingly, and intelligently. The court must make a case by case determination based upon the totality of the circumstances as to whether the waiver was constitutionally sufficient. One of the things people need to understand, everybody's stuck on the word by word by word by word. And guys, word by word may not always be what's required. It's just the content and the understanding. We'll see what the judge says on this. Therefore, until the Miranda warning and the waiver are demonstrated by the prosecution, no evidence obtained as a result of the interrogation can be used against the defendant. The defendant was in custody for the purpose of Miranda. The custody encompasses not only the formal arrest, but any restraint of freedom of movement of the degree associated with formal arrest. A person is in custody if the responsible person is placed in the same position would believe that his or her freedom of action was curtailed to a degree associated with actual arrest. So, when she was inside the vehicle, in the front seat of the cop car, how many of us associate the front seat of the cop car with being arrested? Nobody. When you're in the front seat of a police officer's car, do you assume you're under arrest? No, because when you're in the front seat of that police officer's vehicle, you kind of feel like you're equal. Hey, I'm just sitting out hanging. You're asking me questions. Now, if she was placed in the back seat and the door was shut and then they started questioning her, then this would apply. Escorted home, maybe. Number 70 encompasses not only the formal arrest, restraints of freedom. Did I read that? Yeah, I did. Number 8. Here, it is uncontroverted defendant was in custody for the purposes of Miranda on February 25th of 2020. The defendant arrived at the Orange County Sheriff's Office where she was directed to an enclosed interrogation room. Therein, she was surrounded by 2 detectives. They were in the room. She chose where to sit. They didn't tell her to sit there. I watched it. Constable and Owens. Furthermore, Owens' firearm was visible on his waist throughout the interrogation. Therefore, bull crap. No, she was read her Miranda rights and she waived them. You can't go there. Okay, let's talk about this. I have a lead shooter that I can wear legally concealed or unconcealed, depending on the situation. And if I take you into a small room and I'm interviewing you for, I don't know, disability purposes, would you assume that you are not free to go? When there's a weapon on someone does not mean that it is limiting your ability to move freely. There are people who wear them in a lot of different venues, including probation and parole. Including but not limited to probation and parole. So, in my humble opinion, I think they're throwing crap at the wall, but I respect his creativity in this. I'm not saying he's wrong. Someone should line up the courthouse with suitcases. Oh, wouldn't that be horrible, y'all? That would be horrible. The defendant was subjected to interrogation for the purpose of Miranda. Number 9, interrogation is any question or action by the state agent that is likely to elicit an incriminating response. Number 10, in the instant manner, defendant was directed into an interrogation room, where she was subject to investigative questioning for 2 hours. I'm like, please, that's so minimal. The people who've been in there for 12. It is undisputed that the line of questioning exhibited by both detectives was likely to elicit incriminating response. Therefore, the court should find the defendant was subject to interrogation for the purposes of Miranda. Oh, I know. I wouldn't want to do that. Absolutely not. Literally. Figuratively, that would have been interesting, but literally, absolutely not. The court must determine, oh God, you're making me nauseated, must determine based on the totality of the circumstances whether a voluntary and intelligent waiver of Miranda warnings has been made. In making this decision, the factors considered by a court include the background, experience, and conduct of the accused. All right, they just screwed themselves because she's been interrogated before. She's been read her Miranda rights before. She's been in jail before. So her background, her experiences would lead her to understand those prior to this. Now, if you've never been arrested, never been interrogated before, never had Mirandas before, you wouldn't know this. First, the detective minimized and downplayed the significance of the Miranda rights. Hey, they can do that. She read it. End of discussion. It's one of those things. It's like they can lie to you to a point. I'm trying to get this in quick because court may start. Where the police minimize and downplay the significance of the warnings of the purpose of the Miranda is undetermined. In the instant manner, the purpose of Miranda was undermined as the follows. Detective. Okay. Here we go. So I can keep it up.
So, obviously, he received his autopsy. So I'm going to read you your rights again because we have to talk about that. And we're not done talking about the incident. We just have to do it.
Just like we did yesterday? Normal protocol.
Remember, I read you the rights, just like we did yesterday. Yeah, it's the exact same thing, but since I'm asking you follow-up questions, I need to read them to you. Okay?
So, the aforementioned line of the communication highlights a coercive nature. The detective copes still. In addition, apparent that the defendant. Sorry, got to do it. That the defendant did not believe. Sorry. At that time, that she had to speak to the detectives, and the warnings was just formal protocol. Y'all, doesn't matter if it's a formal protocol or not. When you're read your Miranda rights, you shut the hell up. Just saying. 14. The defendant was not properly informed of her rights to make a voluntary and intelligent waiver of such. Detective Copesell, failed to ask the defendant. Really?
Have these rights in mind. Do you wish to talk now?
Finally, based on the circumstances surrounding the interrogation, the defendant's statement was coerced and not freely and voluntarily given. The defendant did not freely and knowingly waive her rights to the Miranda. As such, the entire 2-hour interrogation should be suppressed. Holy crap, are you crazy? Let me make sure we don't have any more stuff hitting, because they're getting ready to pop off. State's response is already hit, but we don't have the papers. Geez, you're hitting this close to trial? I am shocked. Not. This box is driving me crazy. I got to find a home for it. Oh, that's my magnet fishing box. So I'm going to read some of y'all's comments, because they are definitely setting up for trial. We are definitely setting up for trial. I'm going to keep refreshing until I see this document hit. Well, here's the thing. Was she not detained? No, she was not. Detainment, she was not told she couldn't leave, nor did she attempt to leave. And that's another question. Did you try to leave? And when you tried to leave, did they tell you? I'm putting socks on, my feet are cold. Did they tell you you could not? See, that's the other thing. She did not ask to leave until she knew she was going to be arrested. And at that point, they said nope. You know what's amazing this time of year? How wonderful warm, fuzzy socks feel. So let's go into, my brother is mildly autistic in his 60s now. He could never corner him with blame, reminds me. Well, yes, but that's not what's going on here, y'all. That is so not what's going on here. And that's what's frustrating me, is that people are throwing a lot of stuff around, but under the law, she was clear. Oh, I know this judge is awesome. Motion hearing to find out she'll be allowed to have makeup, hair done, and wearing civilian clothes, and to throw out her police interview. Exactly. Have y'all ever had a day where your neck needs to pop and it just won't do it? On that right now. That's what I need. Minimize. I've got so many windows open. It's not funny. I'm not used to this. Okay. It hasn't posted. I'm going to go back and look at some of these because there's a lot of comments I did. Should line the car. Okay, there we go. While she was being interviewed at the courthouse, she never asked to leave. She stayed in the room saying unintentionally until she just pissed us all off. You are so right on that, Ronnie. At this point, her lawyer's throwing stuff at the wall to see what sticks. Yeah, sort of. But do you know what? That's what he's supposed to do. And I know a lot of people are kind of giving him a hell, but honestly, he's doing his job and doing it well. That's the head bailiff. He's like, yeah, I'm on camera. Head sheriff there, deputy. She knew she was playing a game. She knew she wanted, yeah, exactly. Yep. Well, she wasn't smart enough to be her own attorney. I think she realized she made some hell of a mistake by getting rid of some of her attorneys.
What? You don't like my voice? I can go deeper. Oh, come on. Come on. You want me to go higher? I can go higher. Sounds like something's creeping up.
Hey, gotta keep it interesting. Keep y'all awake. Sorry. She knew exactly what she's doing. She's manipulating. It has to eventually work for her so far. Well, that's the thing also, is how much has this worked for her in her life in the past? Obviously it has. Personality disorder? Case one? You think? Definitely. We do have a potential of delayment of trial. We'll find out today. The thing is that the prosecution was supposed to be able to have a deposition with somebody Monday. If that has not occurred yet, the trial will be delayed. We do like this judge. I don't see it being tossed either. Exactly. Ronnie, you just tell your husband, put your big boy boots on and deal with it. I got court, honey. Court come first today, honey. I'm teasing. Always take care of your spouse. Always. Put them first.
So, would this cause a nightmare?
Or how about this?
We may go back and forth.
And then you sit here and you go, oh God, I think I'm having a double multiple personality
Disorder, yeah?
Okay, if it really creeps you out that much, I won't do it. Oh, look at her walking in. Oh my God. Wait a minute, y'all. I thought she wasn't supposed to have her hand shackled for this. I thought she was supposed to be. Oh, they should unshackle her, undo the waist. Yeah, right. Yep. I know. But you know what, guys? Her hair really does look decent considering the way she looked before jail. Jail's done her good.
toxic. Just a good old guy. I ain't doing anything wrong. Now, when I put a Texas accent on it, does that help any? Or do you not like this one?
All right, I'm done. I just can't. I'm done. I'm done. Are you going to sleep like a cockatoo? Well, she did say she took care of him. Yep, she took care of him all right. Matt, please. Okay, I'm refreshing like crazy to see if they're going to get this, but I don't think it'll happen before court, but I will continue to watch it. Oh, she's going to complain about that. They may take it off in a minute. They may not allow it to come off until they're really right up on time to start. Who knows?
I'm sorry. Is this better? Bring the jury. Bring the jury. Bring the jury.
I need to get someone. All right, anybody out there know how to make sound bites? Me try was not successful. I want the sound bite from the Murdaugh trial. Bring the jury. And then I want the sound bite of this cray cray woman. That one going, we had a good day. It was a good day. I want to have one of those so when I'm having a bad day, I can push it and realize, yeah, I'm really having a good day.
Santa baby, just slip a sable under the tree for me. Bum, 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 ba-da-dum.
I could really have fun with this. What is our favorite quote? Good one, Ronnie. What's the favorite quote? It's real simple. The first one, her. In the interrogation, if you have the whole video, I think it's 2 hours, 46 minutes, and 26 seconds, because Lord knows I tried many times to grab it. 2 hours, 46 minutes, 26 seconds. There. Okay. I know you're a good person.
You're a very good person.
So, in the full interview, if you just go back to my live that I did the other night, where she's in the interview, you're in a okay. We'll send it to you later. No problem. But I want that for trial next week. So when the crap's hitting the fan, I can push that button. I'm having a good day. So nothing's torn. Thank Jesus. I wonder if she has a potential bone spur that's hitting that tendon. But then again, just a curiosity. All right, let me know. Keep me posted. Tell her we love her. Y'all, my friend, oh my gosh, that's a lot of pain she was going through today. I'm just glad they went to the ER because she needed some pain management bad. Oh, almost thought we had it. Oh, I would love to have that too. I'm a good person. Oh, I know. Maybe I ought to put on a nun's habit and get a wig and cut it like Sarah Boone. and be the Sarah Boone nun. Oh, I love that. I love the musical Chicago. I love the movie too. They did a really good move. They did a really good one. A hobbit. I need a nun's hobbit. And I'll get a wig and I'll do that cut to it. I actually have a bunch of wigs at home. I'll do that cut to it and I'll dress up as the Boone nun. I don't know who I am. I feel like we have a cat in here. Ah, there it is. I had a it felt like a hair's rubbing my nose all morning. There it is. Got it. Hello from West Virginia. Hi, Dawn. Hello. Welcome. We are really kind of in a weird mood today. I'll be honest. I probably chased a few people off. You excel at everything. Wonderful. I don't do anything wrong and I do everything right. Oh, because she says she's a good girl. I'm a good person. And somebody said that, well, it was said up here that when she says that, they picture her in a toxic orchid right here. When she was saying, I'm a good person, I honestly envisioned her as a now my nose is going to keep itching. Yeah, we all have those days. Guys, I woke up. I only had like 4 hours sleep again last night, maybe just a hair more. I had a monkey with me. Oh, I love having my monkey with me. I'm not complaining. For till about 1 o'clock in the morning. It's here. Oh, crap. I got it. Yahoo, guys, we got it. Okay, we're going to have this until they decide to get off the pot. Okay, let me do full page, full screen. I got to do this. I won't see your comments for a moment. I'm going to read through this real quickly. We'll go through and do a deeper dive, but I just want to quickly see what we're looking at. The state response comes out of the state of Florida. The defendant filed a motion to suppress, blah, 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 blah. On September 30th, the defendant had filed an additional case law with the court. These appeared, okay, we already know about that, issues outside the four corners of her motion to suppress evidence. The states object to any additional claim being raised at a hearing that were not specifically pled in the defense's motion. In the case, while not actually having a video surveillance of the defendant committing a crime, the police threatened to seize his truck 3 times, and the alleged and the defectives in the case never said they had any evidence they did not have. Like I said, we're going to zoom through this and then go back and read more. And the defendant declined viewing the video she made while the decedent was in the suitcase, asking to be let out. There was never any threat of police taking any action or inaction based upon what she told them. This case is in what's it? The defendant's next summons, whatever the law enforcement specifically asked the defendant if at some point somebody gets enough, then they have to do something to defend themselves. And the defense said, I would just flee. I didn't know if you blank. There was never any suggestion, as there was in Johnson, that self-defense claim was her only way out, much less that she would not go to jail if she claimed self-defense. In fact, the defendant repeatedly and adamantly denied that there was any problem that night. It was a good night, Your Honor. It was a good night. And denied that she did it intentionally. It's unintentionally. While the defendant was questioned about how much she had to drink that night, just a few cups of the homicide, she stated the reason. We're getting close. Okay, guys, I tried, but I have it. There may not be any interpreting for this, so I may have to go in interpreting mode. If I do, please forgive me. If I don't talk. Well, I hope not to talk. It'd be rude of me to do so. Thank you, love. Here we go.
You can catch straw on behalf of the state.
William J. for the state.
James Owens for Sarah Boone.
I do.
I have this game.
Good afternoon, everyone. Ms. Boone, good afternoon. If you could please state your full name and date of birth for the record for me.
Sarah Boone, 10-10-7-7.
Okay, we're here on several different matters, including a motion to suppress, specifically the motion to suppress defendant statements at OCSO filed September 24, 2024. The amended motion to suppress defendant statements at OCSO filed September 30, 2024. And then just what was filed this afternoon at 2:35 p.m., defendant's second amended motion to suppress defendant statements at OCSO.
We'll sing happy birthday
Stated
to
here
her.
the opportunity
We'll
to
sing to
review
her.
the second
Mhm.
amended motion.
We will.
Are you ready to proceed on that today? Okay. Are there any housekeeping matters we need to address from the state side of the ledger?
Not on that motion.
Okay. Any housekeeping matters on your side of the ledger, sir, with regard to those motions to suppress?
No, sir, Judge. I believe we've got detectives outside to testify, and we've also got the custodian of records from the Orange County Sheriff's Department relating to the Miranda card and the policy.
Is that a valid argument that you're still embarking on this afternoon based on what's in your second amended motion?
Yes.
Okay, so the sufficiency of the Miranda waiver is still at play?
Yeah.
Okay, all right, thank you, sir. With regard to the other motions that were set for today, and I have reviewed the state's motion to strike, and I have reviewed all the case law authorities that y'all have provided to me as well. With regard to the defendant's motion for hair, cosmetics, civilian and clothing without restraints for trial, Mr. J, do you have any position with regard to the restraints at trial portion of that motion?
I believe the law of the case has already been settled on that issue.
Okay, all right, we'll entertain argument when we get there. And I've also reviewed
Because the jury is
state's
not
request for
present.
protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting.
With September 30, which is also set to be heard this afternoon. Okay, all right, we'll entertain argument when we get there. And I've also reviewed the state's request for protective order filed September 30, which is also set to be heard this afternoon. With that, we'll begin with the motions to suppress. State, you can call your first witness.
Judge, I'm not objecting to the authenticity of whatever it is he subpoenaed. I've been getting some of the documents, Orange County Sheriff's Office General Order 711. I don't see any need to belabor the custodian of records sitting around. Was there something else? Was there actually a Miranda card? Or
Yeah, if you look in the very back. If you look in the very back,
Okay.
you see the Miranda card, the last page, and the next to the last page.
Yeah, there's no need to keep the custodian of records around for authenticity. We still have our objections.
Okay, all right. Can the custodian then be released by virtue of the state's stipulation as to that, those records?
Yes, can I go tell what you do?
Yes. I also have reviewed the 2 hour and 6 minute investigation that's pertinent to the motion to suppress. The court has reviewed the entire video. With that, State, you may proceed.
State would ask the court or the clerk to mark A for identification as a DVD, courtesy copy, body worn camera.
And I have reviewed all of those in advance of today's hearing. Any objections?
No objection.
What was pre-marked as States A will be received into evidence without objection as States 1. Good afternoon, ma'am. Could you state your full name for the record and spell it for us?
She's had the baby.
H-E-L-S-E-Y. Last name is K-O-E-P-S-E-L-L.
Thank you. Counselor, your main court.
Thank you. Where do you work, ma'am?
The Orange County Sheriff's Office.
What do you do for Sheriff Mina?
I am a homicide.
How long have you been a homicide detective?
6 years.
What's your total experience with the Orange County Sheriff's Office in terms of years?
I am going on 12 years.
Any prior law enforcement experience prior to joining the Sheriff's Office? And in the homicide unit, how is it that you get notified that you shall be the lead investigator on a case?
So for this case specifically, my team was on call that week for homicides. And so the deputy on the scene would notify the call center to notify the on-call homicide.
All right, and is it fair to say that you guys have 3 teams of 4?
Yes.
And each of the third weeks you will be on call?
Yes.
And then through some other random distribution, it's determined who of the 4 will be the lead?
Correct.
And it was your turn to investigate the death of Jorge Torres?
Yes.
And you were notified of this on February 24th of 2020 in the afternoon?
Yes.
About what time were you notified?
I would have to look at the CAD sheet to recall directly, but I would assume within 30 minutes to an hour of deputies being on scene.
All right, and do you go to the scene first or do you do anything else?
For this particular incident, I got my partner, Detective Sarah Boone, and we headed out to the scene.
All right, and when you got to the scene, what did you do?
I met with the deputies there, and they kind of just briefed me on what was going on and what they responded to.
Did you do a walkthrough of the scene?
I did, yes.
And then was a search warrant drafted for the residence and later executed?
Correct.
Did you have any contact with somebody identified to you as Sarah Boone on the scene?
Yes,
Do you see Sarah Boone in the courtroom today?
I do.
Can you point out where she is and what she's wearing?
She's over here on my left, and she's wearing blue.
May the record reflect she's identified the defendant.
Record will so reflect.
When did you first have contact with her?
If I'm not mistaken, she was outside of the apartment when I got there. So once I spoke with deputies, I then went and introduced myself to her.
All right, and did you ask her any questions at this time as you guys are standing outside of the residence?
Not like detailed questions about like what happened, because I already was told by deputies what she had told them. So it's more just to like introduce myself and to let her know, you know, we're doing a search warrant and the procedures of how we do things.
And when you respond to a scene, do you respond in plain clothes?
I do, yeah, like business professional.
Like what you're wearing?
Yes.
And when you made contact with her outside of her residence for this first contact, were you alone or was your partner Scott Lowen with you?
I believe Scott was with me.
And was he also similarly dressed in business casual?
Yes.
All right. And so how long was this initial interaction with Ms. Boone?
Not long. Maybe a couple minutes, 2 or 3 minutes.
Okay. And this was out on the sidewalk in front of her home?
Yes, if I'm not mistaken, she was at a neighbor's residence, like sitting out on their like front porch area.
Do you recall what you asked her in this initial contact?
Do I recall what?
You asked her?
No.
Okay. So it was just a couple of minutes that you were there with her?
Yeah.
Okay. And then what do you do after your first contact with her?
So once I did my walkthrough, we decided to go with a search warrant for the scene. So that was written by somebody else. And then once that was executed, we went in there further with CSIs. And then we talked to Brian Boone, which was the ex-husband. And then I believe we then sat Sarah into our unmarked vehicle and had a conversation with her.
Was that conversation in the unmarked vehicle recorded?
Yes, audio recorded.
And can you describe this unmarked vehicle for the court?
At the time I was in a unmarked Pathfinder, so it was like gray in color, didn't look like it didn't say like law enforcement or police or anything on the exterior. And there were lights like inside.
Where did everybody sit in this Pathfinder?
I sat in the driver's seat, Sarah sat in the front passenger seat, and Detective Scott Lowen sat in the back seat.
Did you have any conversation with her about the facts of the case or your investigation that wasn't recorded inside the car?
No.
And that was all recorded and turned over to the state attorney's office?
Yes.
And you announced the date and time of the start of this interview on that recording, did you not?
Correct.
Okay. Is it fair to say that it had been about 3 or 4 hours since the initial call out for 911?
Yeah, I would say, yeah, because I believe we started interviewing her right before 5 p.m.
And is there any particular reason for executing the search warrant and speaking to another witness or witnesses prior to interviewing Ms. Boone?
Just based off the situation and what was happening.
Okay. Is it in any way unusual to gather evidence before talking to the last person to see a decedent alive?
No.
At some point during this day, which was February 24th of 2020, was her cellular phone device collected?
It was
And when was that?
that same day.
I mean, when time-wise and in relation to talking to her?
Oh, well, I noticed the phone was in the kitchen area, but I didn't touch anything until CSIs documented everything, photographs. And, so I don't think I really touched it until after I had talked to her about going through it.
All right. And ultimately, was she placed under arrest on February 24th, 2020?
No.
After she got out of her car, was she free to remain on the scene or free to leave?
Yeah. Not go back in her house. But
Prior to that, had she been detained and requested not to leave the scene?
one more time.
Prior to your interview with her in the car, had she been asked or ordered to stay on the scene?
Not by me.
Okay. February 25th, was there a second interview conducted with you and Detective Lowen with Ms. Boone?
Yes.
Prior to this interview, had her phone been extracted by any member of the digital forensics team at the sheriff's office?
Yes, it had.
All right, and had you reviewed some of the evidence on there?
Yes.
You had requested that Ms. Boone come down to the sheriff's office rather than you returning to the scene.
Yes.
Can you explain that?
It's more of a controlled setting for law enforcement. We were able to audio and video record at the sheriff's office, and she had mentioned that she might not be staying at her apartment, and so I didn't want to go to the ex-husband's residence where her potential child was, so I just felt it was a more controlled setting at the sheriff's office.
All right. And when Ms. Boone arrives at the sheriff's office, who goes down to greet her and where?
But she would have gone in through, we have two entryways. So either on the record side or on the opposite side. And she would have had to go up to a window and request that she was there to meet with me. They would call me. I would tell them yes, sign her in. And then if I'm not mistaken, I believe Scott, Detective Lowen went down and got her.
All right, so you're describing two separate entrances that members of the public can come and go through,
Yes.
as opposed to separate entrances that might be on the back of your building where people are not free to come in and out of without a swipe card.
Yeah. The public doesn't have access.
All right. Now, in relationship to those two entrances, which I assume are on the first floor of the building, is that a safe assumption?
Yes.
Where are the CID or the investigation division's interview rooms?
They are located upstairs.
All right. And is she allowed to just walk up to the second floor interview room, or does she have to be with an employee of the sheriff's office?
She would have to be with an employee of the sheriff's office.
And your testimony is it wasn't you?
I don't believe so, no.
Now tell us about these interview rooms.
We have 4 interview rooms that are audio and video recorded.
Okay. And they have, you said they're video recorded. Was the interview with Ms. Boone video recorded by the sheriff's office equipment?
Yes.
Was there any conversation about the case or the investigation with her that did not occur inside that room with the recording going?
No.
Okay. I don't have other questions of this witness.
Thank you. Any cross-examination?
Yes. Detective, I'm James Owens. I met you outside just a few minutes ago, and you know I represent Sarah Boone. Detective, have you had a chance to review any paperwork related to this case prior to this hearing?
I have looked at my investigative report, and I have looked at some policies, but they were from current.
Have you had a chance to view Deputy Kayla Rodriguez's body cam video prior to today?
I've seen it. I have not seen it recently.
Have you had a chance to review and listen to the audio interrogation that was in the unmarked vehicle that you did of Sarah Boone on the day in question?
Yes, I have reviewed that.
And have you had a chance to review the approximate 2-hour interrogation video at the Orange County Sheriff's Department?
Yes.
Would it be fair to say that prior to you asking Sarah Boone to enter this unmarked vehicle for this interrogation with Detective Lowen, that you did a preliminary investigation as to whether or not this was potentially a homicide?
Yes.
And you would have viewed the scene inside the apartment?
Yes.
And you would have spoken to Deputy Rodriguez about what she knew about the situation?
Yes.
And you would speak to Deputy Rodriguez about what Sarah Boone had said had happened?
Correct.
And did you talk to any other people there about the situation prior to speaking with Sarah Boone about the facts in this case?
Just Brian Boone.
Okay. And was that conversation recorded with Brian Boone?
Yes.
And would that have been in your squad car?
Potentially. I didn't listen to that interview. I don't
Okay.
know if we interviewed him outside or in my car.
Was he Mirandized?
No.
Okay. So although he was at the scene when y'all showed up, he was not considered a suspect or person of interest?
No.
At some point, did you determine that Sarah Boone was a suspect or person of interest?
At some point, yes.
Tell us when that happened.
The next day.
Okay, so at the time of this event, your initial appearance there at the scene, which I understand you must have stayed 4 or 5 hours?
Probably.
Okay. At that point, at no time did y'all consider Sarah Boone a suspect?
Well, it's difficult to the way you're asking, but she was the only one there. She's claiming that no one else was there. So what I was being told would mean that she was the only person of interest in that situation. But due to not having the autopsy results, we just interviewed her initially, got her initial statement, and then pending, once the autopsy was completed the next morning, was when I already knew I was going to meet with her again to discuss the autopsy results. So then we had another interview with her where she was Mirandized and she went to jail later that evening.
While you were there on scene, I know at some point you saw her phone on the kitchen counter.
I did.
All right.
Or maybe on the microwave. It was somewhere in the kitchen.
All right. And at some point you went to Sarah Boone and you asked her for the password to open the phone.
We asked to go through her phone.
Did you ask Sarah Boone, can I have the password so I can go through your phone?
Yes, after she signed the consent form.
Okay, so not before? You didn't ask her before you asked her to sign the consent form? Sarah, give me the password to your phone.
Not that I recall, but I would normally have her sign the consent form first for her consenting to go into the phone and then gather the passcode or whatever it is.
Well, how would that have even come about then? I mean, how would you have approached her about signing the waiver to consent to searching the phone?
She called 911. So I told her that we needed to corroborate her story as to what occurred.
Okay.
And so to do that, I wanted to go through her phone.
All right, do you know about what time she signed the consent?
No, I don't think it requires a time on there. But it was when we were on the scene initially.
Was it prior to her interrogation in the unmarked vehicle?
Yes.
And after she signed the consent, did your testimony is you asked her for her password and she gave you her password after signing the consent to search the phone?
Yes, I didn't touch the phone until my digital came.
All right. You're talking about the digital investigator? And they have the ability to open up the phone and search the phone?
With or without a password, yes.
But y'all utilized the password that Sarah had given, had you not?
I believe so.
Okay. And do you know how long it took for the digital investigator to show up after you arrived?
Oh yeah, she didn't come until later. I believe around 7 p.m.
Okay.
That's when in the CAD sheet it says she arrived.
And you know there were two videos on Sarah's phone.
After I spoke to Sarah.
I'm sorry?
After I spoke to Sarah?
All right. So what I'm gathering from what you just said is at some point you asked or directed Sarah Boone into your unmarked vehicle where you interrogated her. Is that correct?
Where we completed an interview? Yes, sir.
And your testimony is that you did not view the videos that were found on her phone. And I'm referring to the 2-minute video of George in the suitcase. And then some time went by, and I think there was about a 22-second video of George in the suitcase that Sarah took of him in the suitcase. Your testimony is prior to you putting her in your unmarked vehicle that you were not aware of those 2 videos.
That is correct, sir. I did not go through her phone until digital forensics came out and then went into her phone. And then she brought me over to her van to tell me about the videos and what she found.
All right, so your testimony is at the time that Sarah Boone was interviewed in your vehicle, that the forensic phone investigator had not arrived.
Correct.
Okay. Did you tell Sarah, I know we saw the audio once you get in the car, but did you talk to Sarah before y'all got in the vehicle?
Of course.
And did you tell Sarah that y'all wanted to talk to her and this was routine protocol?
Yeah, that I wanted to have a conversation with her. And once I had walked through the house and saw what I was working with, we would have that conversation.
Did you tell her that interviewing her in the squad car was routine protocol to your investigation?
I don't recall if I specifically said that, sir. This was 2020.
Okay. If she recalled that, would you dispute it?
Objection, improper question. Sustained.
Your testimony is you don't remember saying that.
I don't remember specifically saying what, one more time. What is it that she claimed that I said?
Routine protocol.
I would not interview her, not in my unmarked car. So my routine protocol, sure, I would do that. I would
Okay.
interview her in a spot where no one can hear us.
And you would explain to her why you were doing that, wouldn't you?
Would I explain to her why we were sitting in my car? Or
Yeah.
Standing?
Yes.
No.
Well, you would have to tell her something.
I said, yes, we're going to go have a conversation in my car now.
Okay. And did she have any questions that you recall about what's this about? And you could have potentially explained to her that this is routine?
It was all explained on the audio recording.
Okay. But you agree you had a conversation with her before you got into the car with her?
Yes, I definitely directed her to get into the front passenger seat when we were going to talk in the vehicle, yes.
Okay. And you don't recall whether or not you said this is routine protocol to come into the car and talk to me?
Those words specifically, no. But
Okay.
I would have talked to her in the vehicle regardless. I would not have talked to her outside of my vehicle.
All right. Now, once inside the squad car, you were there with the other detective, Detective Lowen. Okay. And you read her the Miranda rights card, correct?
Yes, from my card, yes.
Do you agree that you didn't ask her the last question, number 9?
Objection, relevance.
Response.
Judge, we're here on a hearing on the issue about the interrogation.
But of the case law that you provided to me, none of it stands for the proposition. Miranda identifies the 4 things that need to be addressed. Not one of the cases talks about that issue of reading that language at the bottom of the card that is in the motion upon information and belief. This is what it says. So how's it relevant for the purposes of today?
Well, it's relevant because this is the policy of her department.
But
Judge,
what does the policy have? But now we're getting away from the card to now the policy. There's nothing about the policy right now. The question is about what the card says.
Okay. The card is the policy, and the policy is the policy. They're intertwined. They refer to each other. Our argument is that she did not waive her rights.
But
Remain silent.
that's a different issue than what is on the card.
I understand, but it's a coercive question about her not doing that, which was the policy of her sheriff's department. She elected not to do that. She wanted a statement from Sarah Boone at the scene. She wanted a statement from Sarah Boone at the sheriff's department. She elected not to answer a question that the policy says read verbatim from the card. Why did she not want it? Our position is it was an attempt by this detective to coerce Sarah Boone into talking.
On February 24th or on February 25th?
On February 25th, this interrogation ties into that one. She used the same routine protocol that she used for the second one. The first one, she claims that my client wasn't a suspect, wasn't a person of interest. At the sheriff's department, I'm sure, I haven't talked to her about it yet, but I'm sure she's going to say, yes, she was a suspect. Yes, she was a person of interest. Yes, we had probable cause to arrest her prior to her giving a statement. But what she said in terms of routine protocol the day before was what Sarah was relying on when she said routine protocol, when she questioned the detective about routine protocol the very next day in the interrogation room. And for her not to give that question goes to the totality of the circumstances as to whether or not my client, Sarah Boone, actually waived her right to remain silent. If she understood her rights and then she consciously and freely waived her rights. She was not asked that question. She was not asked that question in the car. She was not asked that question. But that totality of the circumstances comes into play for the court to consider, this court or an appellate court to consider as to whether or not that statement should be suppressed.
Any other response?
Judge, just like it's irrelevant what the sheriff's office policy is compared to what the Florida case law says about our right to not be compelled to give statements under our Constitution in the state of Florida or the United States and federal case law and the state case law interpreting the United States Constitution, the policy is irrelevant and the officer's subjective intent is completely irrelevant in a motion to suppress, just like it would be in a traffic stop under Wren versus United States. What matters is objectively what was spoken to the defendant, and I would ask that we honor the local administrative order and call people by their surnames and not their first names. What matters is that the defendant was read what the case law requires. Anything about the policy, anything about the officer's subjective intent is completely outside of all the case law submitted by both the parties.
Last bite at the apple.
I'm sorry.
Last bite at the apple. Last bite at the apple. Any other argument?
Judge, we're talking about the totality of the circumstances, whether it was coerced or not. You can take any technique or a non-technique, something that you use or don't use, to establish whether or not it was coerced or not. The fact that she didn't read, do you understand the rights? Do you understand these rights, which is the form, the Miranda warning form? Do you wish to talk to us at any time? That's on the waiver affidavit. On the other form, which is the policies form, it says, do you understand these rights? And then the question number 9, do you wish to talk to us at this time?
Objections overruled.
Thank you. And you're referring about surname. What do you mean by that? You mean,
That means last name.
okay, what did I say? This
You
detective?
keep calling the defendant by her first name.
All right. Can I say Sarah Boone?
Either Miss Boone or Sarah Boone, that's fine.
Okay.
You may proceed.
Have you had a chance to look at the standardized Miranda card issued by the Orange County Sheriff's Office? Do you agree that you did not read the 9 questions to her in your squad car?
All 9 questions is?
Correct.
No, I did not read all 9 questions.
Do you know how many questions you did read to her?
8.
Okay. And the question you omitted is question number 9. Is that correct?
Yes, it's actually not on my Miranda card.
I'm sorry?
It's not on my Miranda card that I read from. You can continue.
What do you mean by that? It was the card that you read, it was not on the card?
Number 9, no, not on my card. We have multiple Miranda cards at the sheriff's office, but yes, that is the, in reference to the policy, yes, that is the policy.
Well, somebody dropped the ball somewhere. Did you fail to get,
Proper question.
Sustained.
did you fail to get the most updated card, or how did that happen, that the 9th question was not on your Miranda rights card?
I've had that card since I started being a detective in sex crimes in 2013.
Have you become aware, as it relates to following this motion,
I've become more aware, yes, that
Okay.
there is that card.
have you gone and gotten the updated card?
Objection, relevance.
Sustained.
When y'all took her phone, Detective, did you tell Sarah Boone that you would be returning to her apartment the following afternoon to give her her phone back? You did not tell her that?
No, I listened to all my interviews, everything that's been audio recorded. No, I did not tell her that. We had plans to meet at the sheriff's office.
Or tell me what you understood the conversation was as it relates to her getting her phone back.
I'm sure she asked when she'd be getting her phone back, and I didn't give her a detailed timeline. I said that, I don't even know if I told her that I decided to write a search warrant on it, because I don't need to tell her that. It's evidence in a crime. I'm allowed to take it, and so I took it, and I wrote a search warrant for it.
Okay. But you don't recall ever having a discussion with Sarah Boone about when you were going to return her phone?
Specifically returning her phone, no.
Okay. Do you recall her calling you later that evening on your cell phone? From her husband's phone? You don't recall that conversation? She called you later that evening?
Do you have documentation of the phone call?
I have her testimony.
Oh, okay. Well, I don't recall the phone conversation.
Excuse me?
I do not recall the phone conversation.
You said that y'all had some discussions about Sarah Boone coming to the station. Was that talked about the day of this event or the next day with Sarah Boone?
It was talked about before I left the scene.
All right. And did you relate to Sarah Boone that she needed to come to the sheriff's department the next day to retrieve her phone?
I don't know if I specifically told her about retrieving her phone, but she knew that I was waiting to hear about the autopsy results and that I would probably have more questions.
All right, so you believe you told her that night, I need you to come back, maybe or maybe not about the phone, but I may have some more questions for you?
Something along those lines. Yeah.
Okay. And when was it that you actually saw the two videos from Sarah's phone? Was it that evening after the interrogation in the squad car?
I've already answered, but yes, it was after the interview.
All right, and was it while you were on scene?
Correct.
Okay. And did you attempt to talk to Sarah again about that at that time? Okay. And so did you let your detective partner know about the videos on Sarah's phone?
Objection, relevance.
Overruled.
Did you let your partner know about that evidence? Okay. And did y'all discuss that issue?
Objection, relevance, work product.
Sustained.
At some point, y'all had to, were y'all working together, or were you making all the calls, or were y'all making joint decisions?
Objection, relevance, work product.
Sustained.
Ma'am?
There's no pending question at this time, ma'am.
At some point, did you form an opinion as to whether you had probable cause to arrest Sarah Boone?
Objection, relevance.
Overruled.
Yes, at some point I did.
Did you make that decision by yourself, or was it collectively made by others with the department?
Objection, relevance.
Sustained. You don't need to answer anything.
Detective, at what point did y'all, that next day, I think you had her coming in the afternoon?
I believe it was around 3 p.m.
Did y'all work on trying to get the search warrant for the phone?
I got the search warrant for the phone, and I believe I submitted it that evening. I would have to look at it though.
Okay. Do you know what time the search warrant came back signed by the judge?
It's documented in my investigator report, but I don't know.
Okay. And would it be fair to say that you told Sarah to come in later that afternoon or the next day?
Yes.
Okay. And would it be fair to say that you worked on the case that entire day until Sarah Boone came in?
Yes, I attended an autopsy in the morning. That's why I asked her to come in at 3.
All right. And what time was the autopsy that morning?
It starts at 8, but I didn't probably get till 10. It takes quite a few hours.
Okay. And were you there alone with the medical examiner, or were there anybody else there?
I don't recall if Detective Lowe was with me or not, but yes, of course, there's doctors there.
Okay. And so in terms of your determination as to whether or not Sarah Boone was a suspect, did she become a suspect after you watched the video, the two videos from her phone the day before the autopsy?
Objection, relevance. The custody is not disputed on the February 25th statement.
How's this relevant? If the issue is knowing an intelligent waiver, the sufficiency of Miranda and coercion, what does the formulation of probable cause have anything to do with anything?
Well, I wanted to bring out the fact that they had already made a decision before she came in for the interrogation on the 25th that they had probable cause to arrest her. So that if she, A, either didn't come in, they were going to go arrest her that day, or B, if she did come in and she exercised or invoked her rights to remain silent, that they were going to arrest her anyway, that they had already made a decision that she was the prime suspect. They had probable
What does
cause.
that have to do with any of the three issues that are raised in the motions?
It's whether or not she was in custodial interrogation, whether she was free to leave.
I don't know that that's being disputed by the state.
I think my response
That's my understanding. The state's
Okay.
not disputing that there was a custodial interrogation, which is why, on February 25th, which is why Miranda was provided prior to that.
Judge, it was provided the day before, and she's just testified she was free to leave at any time.
Okay.
So the Miranda was given on two separate occasions. She wasn't in custodial interrogation. Detective, am I right? The day.
Well, hang on. Before we ask any questions, let's drill with the evidentiary objection first.
Okay.
The objection sustained.
Okay.
You may proceed.
All right.
Ma'am, you would agree that when Sarah Boone arrived that afternoon for the interrogation, she was not free to leave.
She was not,
Excuse me?
she was not going to be free to leave, no.
Okay. And so if she would have remained silent and exercised or invoked her right to remain silent, she would have been arrested anyway. And that was based on your investigation that you had the night before at the scene. It was based on her statements that she had given you in the squad car. And it was based on the autopsy that was performed the next day that you were present for. And it was based on the 2 videotapes that you saw from Sarah's phone.
Objection, relevance as to what the probable cause basis.
Sustained.
You had all that information before you began your interrogation on the 25th of Sarah Boone.
I had all that information.
All the information that I just related to you before you began your interrogation of Sarah Boone.
On February 25th?
That's correct.
Yes.
And you would agree that you wanted to speak to her on the 25th.
Objection, relevance.
Overruled.
Yes.
Okay. And would it be fair to say that you wanted to get statements from her relating to the injuries to Jorge Torres from the autopsy?
Objection, relevance.
Overruled.
Yes, I wanted to have a follow-up conversation in reference to what she told me the night before and in reference to the injuries that she failed to mention.
And you also wanted to question her about the 2 videotapes that you had found on the phone.
Objection, relevance.
Overruled.
Yes, I do
Okay.
want to show her the videos.
And you agree, in your opinion, the 2 videos and the autopsy were inconsistent with the story she had given you in the squad car the day before.
Objection, relevance.
Overruled.
The videos, I'm sorry, repeat your question one more time.
You would agree that the autopsy results and the videos that were extracted or taken from her phone, recording George, those 2 pieces of evidence from your investigation were inconsistent with the statement that she had given the day before in your squad car.
Same objection for the record.
Overruled.
Yes.
And I believe that's ultimately the reason you arrested her, because of her inconsistencies.
Objection, relevance.
Sustained.
Now, you said you had a chance to review the interrogation video at the Orange County Jail on February 25th of 2020.
The Orange County Sheriff's Office.
The Orange County Sheriff's Department. And also, I believe the state attorney had it transcribed. Have you had a chance to read the transcript?
I have not read the transcription. I watched the video with the audio.
Okay. Have you had a chance to look at my motion where the question and answers are typed out, at least the first minute or so?
No, I have not looked at your motion.
Okay. Do you recall you saying to her, "I'm going to have you sit in the green chair"?
Objection, best evidence is the recording.
He's right.
Okay.
Objection sustained.
Okay. Do you agree, prior to reading Miranda, that you mentioned to her that you had received his autopsy and that you were going to read her rights again, but that we had to talk about that, referring to the autopsy?
Objection, best evidence.
Sustained.
Do you recall making some comments to her prior to reading her the rights?
Objection, best evidence.
Overruled.
Yes.
Is it the policy of the Orange County Sheriff's Department to make any statements to them about the interrogation prior to reading Miranda?
Objection, relevance.
Overruled.
One more time?
I assume that's not the first time you've read Miranda to a suspect.
Objection, proper question.
Sustained.
Let me go back to the first question then. Is it the policy of the Sheriff's Department not to ask any preliminary questions prior to reading Miranda rights?
Same objection for the record.
Overruled as relevance.
You would have to show me the policy that you're referring to, but I was not asking her any incriminating questions during that time. I was explaining to her the purpose of the interview.
Well, have you ever been, I understand you must have undergone some training on Miranda rights and how to interrogate somebody.
Objection, proper.
Sustained.
How long have you been with the Sheriff's Department?
Since 2013,
How long have you been a homicide detective?
over 6 years.
Okay. Have you ever been trained or told to ask or not to ask any statements or any questions prior to reading Miranda relating to them talking to you?
Objection, relevance.
Sustained.
Can you tell us if you recall saying anything to her prior to reading her Miranda?
I recall briefly talking about getting the autopsy results, and that I wish to have a conversation with her.
All right. Do you recall again reading her Miranda rights to her on video?
Yes.
Do you recall again omitting question number 9 on the standardized Miranda rights form for the Orange County Sheriff's Office?
Objection, relevance.
Overruled.
I did not ask her question number 9.
Okay. Do they have a Miranda cards form in the interrogation room? So you would have had that on your person?
The song just came to my mind. Isn't she lovely? And yes, I'm singing out of tune on purpose. Isn't she lovely? Isn't she wonderful? Sarah Boone. Sorry, couldn't resist.
You may.
He is stuck on it. Driving me back crazy on it, that's for sure.
Yes, this is our waivers and affidavits.
Is that filled out of waivers and affidavits?
It's filled out by me, but there's something highlighted that I did not do.
And is that form filled out as it relates to Sarah?
We're talking about just this top, right?
Yes.
Okay, I'm sorry. Does it what?
Is that form, is it filled out as it relates to Sarah Boone?
In case, yes.
Is that her signature or what?
Yes.
Did you see her sign it?
Yes.
Is that your signature or what?
Yes.
And is that the consent for the phone?
The consent to search, yes.
On that form, is there also Miranda warnings?
Yes.
That is a form that's standardized by the Sheriff's Department?
Yes.
And you did not read a Miranda from those rights?
From this piece of paper,
Yes.
that's audio and video recorded, that, no.
Okay. You would agree that there's 9 questions on that form?
Yes.
Same objection to the relevance. As far as it being a consent to search her phone, we're not disputing that she was in custody on February 25th, 2020, when she gave a statement to the detectives. And again, under the case law, there's no requirement for this question 9. Under any state case law regarding the Florida state constitutional right to not be compelled to testify against oneself, nor any federal or state case law regarding the United States Constitution, the Fifth Amendment applied to this state through the 14th Amendment that requires that question to be read. It does not go to the totality of the circumstances of the voluntariness of her waiver of her Miranda rights.
Response.
Judge, obviously we disagree,
Then where's the case that supports that? Because as I addressed previously, I read all the authorities. I mean, State versus Owens, State v. Thomas, Powell from the United States Supreme Court, which reversed a Florida Supreme Court decision, all talk about what's required by Miranda. And that question number 9 that you're focusing on isn't included in any of those.
I understand that,
It's
Judge.
the right to remain silent, the right to an attorney, before and after questioning. If you can't afford one will be provided to you. Everything you say can and will be used against you. Those are the things that Miranda highlights. That Miranda opinion itself says that. So what does question number 9 have anything to do with those things if the state case law and the federal case law, including but not limited to Miranda itself and Powell, and then the state case law of Thomas and Owens, all of which were provided either by yourself or by the state, identify what's required, and that's not one of the requirements.
She has a duty to read the rights.
But they were.
I want to finish my argument.
Okay.
She has a duty to read the rights. She has an obligation to ensure that Sarah Boone understands her rights by asking that question. Do you understand the rights I've just read? And then there must be a waiver. Yes, I understand the rights, and I agree to speak to you now. So for that to be freely and voluntarily given, that statement, there must be a conscious waiver of the rights. The problem with the detective is she reads the rights, do you understand the rights? And then she goes right into questioning. She goes right into questioning without saying, do you agree to speak to me? Understanding the rights, do you agree to speak to me now? That goes directly to whether or not it was freely, voluntarily, and knowingly given, the statement, and whether that waiver was. So under the totality of the circumstances, I think that evidence is relevant. It's the policy of the Sheriff's Department. Obviously, she had an old Miranda rights form, but she failed to read what we perceive as a critical question, and she's going to testify about what she perceived at the time that the detective failed to read that question and how it ties into the case. I understand that all they have to read is those 4, but I think under the totality of the circumstances standard that this court has to apply, that should be a consideration the court should consider. I know it was an honest mistake. She had an old card, but still, I feel like it should be considered in your decision.
Anything else, Mr. J?
It's essentially the defendant stating that they want to make new case law.
I'm going to sustain the objection as relevance by virtue of the decisions in Thomas 351, 7th, 3rd, 197, and Owens 41, 7th, 3rd, 352. There's, it's not relevant as to what the questions need to be asked for the purposes of whether a sufficient Miranda waiver was given.
Okay, let's take a quick break there. I can't interpret it anymore. They're too fast for me to do it alone. All right, here we go. Captioning is on. Be right back.
Do you agree, Detective, that after you read her those Miranda rights, you would agree the situation on the 25th, when you were reading her Miranda and about to question her, was different from the situation the day before when you read her Miranda in the squad car.
Yes, I had more evidence.
That was without the autopsy. That was without the 2 videos from her phone in the squad car.
Yeah, I did, at the time of the interview, yes.
And in the squad car, she was free to leave.
I mean, I didn't tell her she was free to leave, but I mean, if she didn't want to talk to me, she didn't have to talk to me.
Okay.
I love interpreting this, but I can only do it with her. It's too much by myself. Thank you guys for being so awesome. I'm out of breath. A lot of work.
That's all the questions I have at this time.
Thank you. Any redirect?
No, thank you.
All right, can this witness be released?
I'd like her to stay.
All right, subject to recall. Thank you.
Dude, really? You're really
State,
rubbing
you
it
may
in
call your
on
next
her.
witness.
No additional witnesses or evidence on this issue, Judge.
Okay, all right. Anything from your side of the ledger, sir?
Diarrhea of the mouth.
Judge, I would like, you stipulated to the introduction.
No, I don't object to the authenticity.
All right, Judge, I would like to introduce. maybe more witnesses. Just that one.
And what is it that's been marked as Defense Exhibit B?
Sorry, I can't help that audio.
Any objection?
Same objection. It's irrelevant.
Is it the form as of now, or is it the form as of 2020 when the? Okay. Can I see it for a moment, please? Thank you. Any additional argument with regard to the state's relevance objection?
Same argument.
No, I'm sorry, Mr. J, I wasn't specific enough. Mr. Owens, to you. Any additional argument? All right, I'm going to sustain the relevancy objection for the same reasons the court articulated previously.
That judge knocked him down good. I loved it.
And Mr.
Oh,
Owens, you
she
have one
must be
additional exhibit
getting
as well?
tearful. That was really reassuring.
Policy of the Sheriff's Department.
That almost felt inappropriate. As much as we're giving him a hard time, you have to give him credit. He stands up what he believes in the law, that everybody deserves the right to.
Do you know what page specifically those policies are on?
And he stepped up to the plate.
Page 14 of 22. And I'll give you,
And he's doing a vigorous
Is it
job at it.
beginning of paragraph 4, waiver of
I want him on
constitutional
my
rights?
side
Yes.
if I was her. Somebody was smiling down on her the day he accepted. Let me tell you that. These are addicting. They're healthier, but addicting.
Okay, I've read pages 14 and 15.
All right, Judge, and
That
then
judge reads the fads.
you go to 13 of 28.
13?
13, well, it's the next,
Oh, there's two different sets. It's a
Split up.
composite. My apologies.
it's split up.
Got it.
13 of 28 at the bottom, P,
Do you hear me chewing?
and then it goes on to the next page,
Hang on with my face.
14 of 28,
That's weird.
specifically 2A on 14.
Anything else?
No other argument, Judge,
Okay.
other than what we've talked about.
Anything further?
Same arguments.
Okay, all right. I'm going to overrule the objection as to relevance as to what was pre-marked as composite C, and that'll be received into evidence. Over objection is states 1. I'm sorry, defense is 1.
Y'all, if you weren't here on this morning's live, her hair looks far
Any
better
further
now. than
witnesses,
it
evidence,
did
or
when she
testimony,
was
sir?
arrested.
Judge, I'd like to call Sarah Boone.
Ms. Boone, approach the
No.
podium.
That on my bingo card?
She was previously sworn at the beginning.
That was not on my freaking bingo card. She's going to testify.
Would y'all be here?
Yes, sir. Hang on, the deputy's got to move her.
They got to move her like she's a piece of furniture. Oh, they got to control her, is what they got to do. They got to have a hand on her when she walks. And they have to have gloves to do it. She can't walk freely.
Ma'am, you've already been sworn. Counselor, you may proceed.
Look at the look
And
she
would you
just
please
gave
state
you.
your full name?
Sarah Boone.
Well, you're going to have to speak up or move the mic.
Sarah Boone.
Yes.
She can't. She's handcuffed.
Where are you currently housed?
At the Orange County Corrections Department.
Have you been there since February the 25th of 2020?
Correct.
Was that the date of this interrogation that we're here for on this motion?
Yes.
Let me take you back to the morning of finding Jorge Torres in the suitcase.
Remember, anything you say can and will be used against you. You understand your rights, as I've read them.
You
to
called 911?
Yes.
Yeah, this is going to be fun, Dawn.
Is it true that Detective or Deputy Kayla Rodriguez of the Sheriff's Department arrived?
Yes.
Her hair looks fine. Why does she need a stylist?
What mental state
It's been
did you
rough.
have at that time?
I was very confused. It was very hazy. I didn't understand the monumental amount of people that were there and what they were doing with taking things from my home. I was worried about my dogs. I was worried about my son.
Dr. Pepper and my
I was
cigarette.
in shock. I was traumatized by the situation and then trying to focus on everything that was going on at my home. I was hungover. I was still, I believe, intoxicated to a degree.
Objection, Judge, move to strike. This is outside their motion to suppress. They have not made any allegations that her statement was involuntary because of her mental state or state of intoxication.
Response?
Judge, we're talking about, I'm just getting some preliminary information.
But
Her interrogation is the next day.
the state has an obligation, and the case law cited by the state requires specificity in the motions. So it's not a game of 20 questions and a surprise.
Okay, this is the
Are
day
you-
before the interrogation.
I understand that.
We're not talking about an intoxication.
But are you going to be arguing anything in conclusion as to what happened on February 24th?
Were you worried about anything else?
I need my Dr. Pepper and cigarettes, Your Honor. I really, really needed them badly.
Any coercive or coercion behavior on behalf of the Orange County Sheriff's Office on February 25? Are you going to bootstrap or link any of those things together?
The interrogation in the squad car and what was said to her prior to getting in the squad car that relates to what she said about it being routine protocol, yes.
All right, I'm going to
That's
sustain
what
the
you
state's
said,
objection.
woman.
Relating to the
You
intoxication.
said it.
Yes. It wasn't raised in any of the 3 motions that have been filed.
Judge, I didn't ask her that. She volunteered
I
that.
understand it. Objection sustained and it's stricken.
Did you speak to the deputy about what had happened?
Yes,
Okay. And then were you asked to stay on scene?
by both, yes. By both detectives, yes.
Okay. How long did it take the detectives to arrive after you had spoken initially with Deputy Rodriguez?
It was not
And my
right away.
lunch.
I don't know specifically, but it was not quickly.
Okay. Did the two detectives, when they arrived, did they take over the investigation?
It was my understanding, yes.
Sustained.
At some point, were the detectives directing you what to do and where to go?
Yes.
Okay. Can you explain what the detectives told you as it relates to you getting in the car? What, was the phone issue before the car?
Yes.
Sustained.
Let me ask you about the phone. When were you first asked about your phone?
From my remembering, it was once they arrived, one of the first questions that Hopesall asked me was if I owned a phone.
And what did you tell her?
I told her it was on the kitchen counter.
All right. And what happened next as it relates to the phone?
I believe that it was brought to her with someone else. I don't remember.
Sustained.
What was the next
How
thing
do
that you
you
were
roll
told or
anymore?
talked to about as it relates to the phone?
Unlock
so
it.
good.
Who told you that?
Detective Hopesall.
How did you unlock it?
She handed it to me and I unlocked it.
How do you unlock your phone?
It was the passcode.
Okay. And when you unlocked it, did you give it back to the detective?
I did.
Did you ever see the phone again?
I did not.
After that incident, was the next time you were spoken to by Detective Copesel was in relation to the interview in the squad car?
Yes, she told me I needed to go with her and Detective Lowen to her unmarked vehicle.
And did she tell you anything about what was going to take place once y'all got inside the vehicle?
That she was just going to be asking me general questions.
Was there ever any mention about
General
normal
questions
protocols?
is relative.
Not that I can recall.
Okay. What about once you got in the squad car?
I don't recall the squad car.
Okay. And that was recorded for the court to consider. And so she read you your Miranda rights?
Yes.
All right.
So you agree she read them? What's the problem? Right there, yo.
Did you answer the
Right there, yo.
questions?
I
She
did.
agreed to this. She read the rights. Did she
Did
read them?
they
Yeah.
ever indicate to you that you were a suspect?
No,
Did they ever
don't
indicate
have
to
to.
you that you were a person of interest?
no,
They don't have
Did
to.
they ever refer to the videos that you recorded on your phone from the night before? Were you ever questioned about those videos at the scene?
I was not.
All right, after they finished interviewing you in the unmarked vehicle, were you allowed to get out?
Yes,
Were you allowed to leave the scene at that point?
I was instructed by both to not.
Okay. And how long did you stay on the scene?
The entire time.
How long was that? How long did it take before the investigation was completed?
10 hours or more.
Okay. At some point, did they all leave?
Yes.
And at some point, did they tell you they were finished with the work there at the scene?
Yes.
Okay. What did you do?
I went inside my apartment and gathered a few things, and then I went to my former husband's residence where my son was located.
All right. And how far was that away?
About 5 minutes.
How did you get there?
I drove
Okay. What was the reason that you wanted to stay over there the night?
because I was terrified of his family.
Now, later that evening, you were going to spend the night there with your son and with your ex-husband?
Correct.
And did you do that?
My son, yes.
All right. Later that evening, did you attempt to contact Detective Copesel?
I did.
And whose phone did you use?
Former husband, Brian Boone.
You said your phone had been seized
Correct.
and you had consented to that? You signed a form allowing them to take the phone?
Yes.
Have there been any discussion about returning the phone?
Copesel told me she or Lowen or both would return back to my apartment to return my phone
And when did they tell you this?
before they left the scene.
And did they tell you they would return your phone where?
To myself at the apartment.
And is that what you understood they were going to do?
Yes.
Was there ever any talk about you coming to the sheriff's department the day of this event?
No.
All right, so later that evening, you borrowed your ex-husband Brian Boone's phone and made a phone call. How did you know Detective Copesel's private cell number?
She gave it to me before she left the scene.
And did you call her?
I did.
Do you recall about what time you called her?
I believe it was around 9:30 or 10 o'clock.
And that would have been on February the 24th of 2020?
Yes.
All right, can you tell us why you were calling her that night?
Before she left and giving me her personal cell phone number, she told me if I were to recall anything or if I just wanted to talk to her about something regarding the case for me to call her. So I took that to heart and felt very uneasy about how they left the scene.
Sustained.
Go ahead.
There's no pending question at this time.
Okay, you were concerned about the case and you wanted to call her?
Yes.
And did you talk to her?
Yes.
What did you say to her?
I told her in all honesty that I felt that she was trying to trick me.
Sustained.
Did you have a conversation about your phone?
Yes. I asked her.
Overruled. You may answer the question, ma'am.
Did I call for a yes or no? She said yes, and now I don't know what's pending and how to check.
Did y'all have a discussion about your phone?
Yes.
Can you elaborate on that discussion?
She told me that I needed to come down to the sheriff's department because she was pregnant and asked me if I remembered about when I was being pregnant. And it would just be a lot easier for her if I were to arrive at the sheriff's department to pick up my phone.
And they're allowed to do that.
Was there any discussion about you being interrogated at the sheriff's department?
No.
Was your understanding the sole purpose of you going to the sheriff's department the next day was to pick up your phone?
Yes.
And the sole reason for the change in plans from them bringing the phone to you was because Detective Copesel was pregnant and not feeling well?
Correct.
So the next afternoon, did you drive to the sheriff's department?
I did.
Tell us, when you parked your car, where you went, what happened?
I parked my car and left everything as regular in my car and walked through the front door and went to the window asking who I needed to see, and they, I guess, rang them upstairs, and Detective Lowen came downstairs, and I thought I was supposed to be picking my phone up over at a particular window. And he says, no, your phone is upstairs. So we would just like for you to come upstairs, and that's where you can pick up your phone.
All right. And so did he escort you upstairs?
He did,
How did y'all get upstairs?
in an elevator.
And what was he wearing?
I believe he was wearing a red shirt along with his firearm and black pants
His firearm was on his waist?
the entire time, yes.
Okay. So y'all got off the elevator. Where did you go from there?
He brought me into a very small room, and they had me sit down, and then from there I had a list of things that I was going to ask them that I might need to do or that I could do.
Okay. So from the elevator, Detective Lowen escorted you directly into the interview room, and we've got the recording, the audio and the video. You didn't go anywhere else prior to that time. Was there any discussion that you made outside, any discussion between you and either detective about anything, the phone, questioning, anything before walking into that room?
No.
Okay. So directly off the elevator and walked into the interrogation room.
Correct.
And then we've got the video on that. Now, you and I have watched the video, correct? And you've seen the motion where I've referred to the questioning, where she asked you to sit down.
Yes.
You recall that happening?
Yes.
Did that refresh your memory watching the video?
Yes.
Do you recall her saying that she had received the autopsy?
Yes.
Do you recall her saying, I want to read you your rights again because we have to talk about that, referring to the autopsy?
Yes.
This was prior to you being read your Miranda rights.
Correct.
She also said, we're not done talking about the incident. You recall that?
Yes.
And then she said, we just have to do it.
Yes.
How did that make you feel?
Sustained.
Were you trying to comply with the officer's demands?
Overruled.
In every way.
Were you trying to cooperate?
In every way.
Were you polite with them?
Very.
And when she said that, we just have to do it, you said, just like we did yesterday.
Yes.
And then you said normal protocol.
Yes.
Is that what she had said the day before?
What do you mean?
Normal protocol.
Yes.
Had she said the same word? Could you said normal protocol to her.
I was reiterating to her what she had said to me the day before.
So she read the Miranda rights to you,
Except number 9.
except number 9. She read the rights and then she said, do you understand what I've just read to you? And you agreed that you had.
Yes.
But you were not read having these rights in mind. Do you agree to speak to me now?
Overruled.
I was not asked that question.
Is it fair to say that after she read the Miranda rights and after she said, do you understand the rights that I've just read to you, that she read right into the questioning?
She did, correct.
So she never got the answer from you. Do you agree to speak to us now?
I was never asked that.
The way that she acted, the things that she said, the fact that they had your phone. Did you get the impression you were not getting your phone back if you didn't answer the questions?
Sustained.
She was in custody?
Yeah, it's been conceded by the state in their response that it was a custodial interrogation.
But she wasn't aware of it. She wasn't aware she was in custody.
What does her subjective perception matter?
Well, under the circumstances, it would matter. I mean, she didn't feel she was free to leave. She was in an enclosed small space. She was.
That all goes to whether or not.
She was being questioned by two lead detectives, homicide detectives. One of them was wearing a firearm. She was trying to cooperate as best she could. I think her position is that she was coerced into answering the question.
What does that have to do with coercion? Those are all factors that under Ramirez as to whether or not it was custodial.
Well, I know some of the factors are whether or not the interrogation actually happens in a police station or not, or whether it happens outside a police station. So just that environment alone.
That goes to whether or not it was a custodial interrogation. That I'm struggling with the connection on that being noncompliance with Miranda, coercion, or the third ground of voluntariness.
Well, and I think it goes subjectively to her and what she was feeling, if she had a free choice or not,
What's the subjectivity matter?
Excuse me, based on
Subjectivity matter under the case law.
based on the circumstances that she was dealing with at the time, whether or not she felt she had a choice.
But what does her subjectivity have to do with that?
I believe it's relevant.
Objection's overruled. I'm sorry, the objection sustained. I apologize.
Did you understand you were not going to get your phone back until you answered their questions?
Sustained.
Did you have some questions for them at the end?
I did.
Did you feel like you had a choice in answering their questions?
Sustained.
Oh,
Ma'am, that day,
I don't know if you heard that, but that felt good.
you came to the sheriff's department to get your phone?
Yes,
Did you know that you were going to be placed in custody?
I did not.
You could always have it on
Did
your
you
phone.
know that you were going to be arrested?
I did not.
Did you know that you were going to be questioned?
I did not.
Were you trying to cooperate with law enforcement based on her statements that you have to talk to us?
Overruled.
Were you there answering her questions because she confirmed that this was normal protocol?
That was my understanding, yes.
That's all the questions I have.
Any cross-examination?
So that afternoon on February 24th of 2020, when Deputy Kayla Rodriguez arrived at your residence shortly after 1 p.m., you were under the influence of alcohol, correct?
Yes.
Now
You were
you
impaired
say
by
it.
alcohol, correct?
I don't know as much as impaired means. It did affect, yes.
Okay. And that was consumption from the night before, correct?
Yes.
So you did not go to brunch that morning and have mimosas or anything else to drink, correct? You consumed no alcohol in your home that morning, correct? So does that affect in any way your memory when you testify about the events that transpired between you and Detective Copesel that afternoon?
Ask one more time, please.
Did the alcohol have any effect on your memory of what happened between you and Detective Copesel that afternoon?
Now or then?
Then,
Did alcohol affect my conversation with her?
there's a jury
No, you're not
instruction
playing
that
this game.
says a witness's memory and perception is pertinent. And I'm
She's
asking you, did the
game wrong.
alcohol that you
Here
were
we go.
under the influence of affect your memory or perception of the events that you've testified to today that you said happened on that afternoon of February 24th, 2020?
So did they affect my answer?
Judge, I don't think she understands the question.
I don't.
Okay.
It's been asked 3 different ways.
So we'll leave it at you were under the influence of alcohol that afternoon, correct?
Judge, I think she said she doesn't know what, she said that she had alcohol under the influence or impaired.
The objection is, the court does not entertain speaking objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that she said she didn't know what it
What are the
was.
legal grounds of your objection?
Look at that smirk.
You may
Oh,
proceed.
wait. The judge is missing it. She knows. Oh, you spinks little thing. I am so sorry. Oh, we're going to back up on that. Watch. Look at this. She's loving every freaking second of
What are
this.
your objection? Entertain speaking
What?
objections. The legal grounds need to be provided. What are the legal grounds of your objection?
I know that
She's enjoying this way too much.
she said she didn't know what it was.
What are the legal grounds of your
coming.
objection?
She's trying to hide it.
All right, you may proceed.
And you understand that you're charged with second-degree murder in this case,
There's
correct?
confusion.
You're facing a potential penalty of life in
Personality are
prison,
you
correct?
using?
Do you understand that the score sheet minimum is probably about 22 and a half years? Okay. And it is your desire to have these statements excluded from the jury's consideration, correct?
Judge, I would object to that.
Sustain the objection.
Your intent is to testify differently than
Any
you have
objection,
testified
Kenneth?
in the statements in State's Exhibit 1, correct?
I would object to that.
Sorry.
I'm not understanding what the question.
This
Mr. J.
is my moment.
Judge, a witness's bias is always at issue when they
This
take the
is
stand.
the
And it's our position that her credibility for all the things that she has testified to today, that particularly the things in conflict with Detective Copsel's testimony, and the court, of course, in a motion to suppress has to consider the credibility of the witnesses, and you are in the best position to do that. The appellate courts are going to be very deferential to you. It's our position that she's biased. She is charged with second-degree murder. She's facing life in prison. Based on the examination that both state attorneys and defense counsel and the state's expert witnessed today, it is the state's belief that she is intending to testify differently than she testified in the statements that she provided to law enforcement in State's Exhibit 1, and therefore she is biased in all the things that she's testified about today because it is her intent to get this statement, all these statements, or the statement on 225 thrown out so that she is not going to be cross-examined and impeached with it so that she can testify the way that she testified this afternoon.
Response.
Judge, I agree with the impeachment about being under the influence. I agree with the impeachment about what she's facing, that she may be biased because she's facing potentially life in prison. He claims 22 years on the low end. I agree with all that. We just got through at the jail meeting with the state's expert who evaluated Sarah Boone. I was present. The two prosecutors were present. It wasn't recorded. He can't be a witness now. If he's going to question her about what was said during that evaluation, then he's putting himself potentially to be a witness down the road. I don't think that's proper cross-examination about what she said there versus what she's saying here.
Anything further? Mr. J.
I am not specifically asking her what she said that was different. And obviously, if I did and she testified differently, I would have to accept that answer. There's no way for me to extrinsically impeach her with that due to the brevity of the time frame that we have all been subjected to. But I do believe it's a fair question to ask her whether or not she intends to testify differently than her statements that are in State's Exhibit 1 and consistently with how she testified this afternoon, and that she understands it would benefit her if these statements are excluded.
So I'm going to sustain the objection based on how the question was asked. I'll allow you to revisit it based on how you just explained it to me.
So
You
try again.
gave statements to an evaluator this afternoon, did you not?
I did.
All right. And without going into the details, would you agree that there are some differences in those statements as to what is in the statements you provided to law enforcement on February 25th of 2020?
Yes.
And you understand that I would be able to cross-examine you on giving inconsistent statements at trial if you take the stand, correct?
I understand.
And so you understand the benefit of this motion to suppress being granted.
Of course.
No other questions?
Any redirect examination? Okay. We can have Ms. Boone return back to counsel's table. While she's in the process of returning to counsel's table, anything else further from an evidence or testimony perspective from your side of the ledger? Okay. Anything else from the state other than argument?
just argument.
Okay, all right. Once Ms. Boone's seated, we could proceed with any argument. And as the court identified previously, I have reviewed all y'all's authorities that were provided.
I love the way they're keeping her butt under control. Wow.
Mr. Owens, it's your motion, sir. You may proceed.
Judge, my understanding of the law regarding Miranda, first issue is, was the defendant in custody, was the suspect in custody? Was it
She
a
enjoyed
custodial
that way
interrogation?
too
We
much.
have agreed or stipulated to that fact. We're referring to the 2-hour interrogation at the Orange County Sheriff's Department. Specifically, we're referring to about the first minute or two of that video. And I think under the totality of the circumstances, the court has to determine whether freely and voluntarily and knowingly given under the circumstances. Judge, law enforcement, after they get a valid waiver of rights, that I'm not going to be silent, that I'm going to answer questions, go ahead, ask me and I'll answer the questions. Once that happens, law enforcement is trying to get a confession. Law enforcement is trying to get admissions that they can later use at trial to impeach the defendant and convict him. The law allows law enforcement at that stage to use deception, to lie, to trick. We found the murder weapon. It's got your DNA on it. Your co-defendant has come in here and confessed and implicated you. All those techniques, when it's really deception, they don't have the DNA, they don't have the murder weapon, they don't have the co-defendant, can be utilized to obtain a confession or an admission of guilt. But prior to Miranda, you cannot deceive. Prior to Miranda, you cannot trick. That right is fundamental. You cannot be compelled to incriminate yourself. You cannot be forced to talk. It's got to be free will and a choice. And so you can't seduce or coerce someone into giving a statement. And the law is clear. When that happens, we've got to punish law enforcement to correct that type of misuse behavior. It's illegal. So you got Detective Kopsel on the one hand. I got to read your rights. And you have a right to remain silent. But within a minute before, the detective is telling Sarah Boone, we have to do this. We have to talk to you. Now, that's confusing. That's deceptive. There's nowhere in policy that that should be allowed or is allowed. There's nowhere in the law that that should be allowed. It's actually illegal to tell a suspect, we have to talk to you. We just have to, before reading Miranda rights. That is an illegal statement. Sarah Boone did not have to talk to them about the autopsy. Sarah Boone did not have to talk further about,
But they
What had
can
happened.
lie. That's right. No one forced.
but that's the
She
implication this
volunteered it.
detective gave Sarah Boone. It
She should get
taints
hook,
the
line, and
Miranda
sinker.
that comes before it.
That's all on her. I have no
You're a
sympathy.
law enforcement officer. I'm trying to cooperate. We've got to talk to you, but you have a right to remain silent.
But the statement of we have to read you the rights was made before we have to talk to you. So your argument transposes those two things chronologically.
Why are we even having it? I mean, why even have the confusion? I mean, we're sitting here Monday morning quarterbacking, but Sarah Boone was brought up there under false pretenses. A traumatic event, she lost her boyfriend. I'm coming to get my phone. I've been tricked into coming up here to get my phone. And I'm sitting here having to figure out what to do about whether to talk to these people or not. And she's talking about my rights, but then saying, we have to talk to you. We just need to do it. And then she reads the rights. Right there within a few seconds of each other. That's improper. It's illegal. It's coercive. It forces this not to be a valid waiver of her rights under that circumstance, coupled with the fact that she came down under false pretenses. Coupled with the fact she doesn't have the ninth question. If you think about it, okay, you got a right to remain silent, you got a right to a lawyer, those 3 or 4 questions, and then, do you understand what I've just read to you? I'm paraphrasing. But then Detective Kopsel goes right into questioning. Once Sarah says, yes, I understand, it's an acquiesce to authority. Okay, let me start asking her questions. The critical question is, having these rights in mind, do you agree to speak with us? That is the time of free choice. That is the time of decision for Sarah to be given that opportunity. But the way I understand, Detective Kopsel had the autopsy. She had the blunt force trauma. Those were not questioned. Sarah Boone was not questioned about that. They didn't know about that until the medical examiner. So she had additional information that she wanted from Sarah Boone. She had the 2 videos from Sarah Boone's phone. She had additional information from the phone that was inconsistent with the statement that Sarah had given the day before. So sure, any detective worth their salt would want a statement. She'd already said we had probable cause. We'd already made our mind up that we were going to arrest her. If she didn't come, they were going to go get her. If she came and said, I want to invoke my rights, she was going to be arrested. They wanted to get some type of admission, confession, statement that they could later use, which they're trying to do now. But under the circumstances, the totality of the circumstances about how she was induced to come down there, about telling them that she had to talk, Judge, it was coercive. We would ask that you suppress the evidence.
Any response?
Judge, the United States Supreme Court has said that confessions are good. They are good for society. It is good when guilty people are convicted. We stand by all the case law that we've cited, and you have reviewed the evidence from start to finish. Under the totality of the circumstances of that 2-hour and 6-minute statement that she gave to law enforcement, she knowingly and intelligently and voluntarily waived her Miranda rights. And
Yep.
under the case law, it was done perfectly fine. There is no requirement that that question number 9 get read. And as far as any credibility issues,
It'll be
that
there
are
for now one,
pertinent,
to
They
the court's
will
analysis,
have
which
that
the state would
question
submit
there.
there's not, because we are conceding there was custody on
They're gonna
February
make sure of
25th.
it.
They are allowed to use subterfuge and deception to get somebody to come to the police station under the case law and authority cited.
Yep.
But if there is anything that is dependent upon the credibility of either the defendant's testimony or Detective Kopsel's testimony, the state would argue for the reasons of her being impaired by her own admission on the afternoon of February 24th, still from the night before, that her credibility is less than Detective Kopsel's. And of course, she has a bias and interest in the outcome of the case, whereas Detective Kopsel has no motivation to not tell the truth about whether she used deception to bring the defendant down to the police station, because that's perfectly acceptable. So we're asking you, for the reasons that we stated in our multiple responses to their multiple amended motions, to deny their motion to suppress. Thank you.
Any further argument, Mr. Owens?
No, Judge.
All right. Tomorrow is a court holiday. The court has had the opportunity to review all the case law. Court's going to prepare a written order, and you'll have it before the close of business tomorrow. Courthouse may be closed,
dang.
but I'll be here working.
Jim, for the record, those two exhibits that I tried to introduce, they will be admitted
Correct.
into the record.
Yes, of course. They were pre-marked. Moving now to the defendant's motion for a right to hair, cosmetics, and civilian clothing
Oh, my God.
without restraints for
Gotta deal
trial.
with that crap.
State, what, if any, positions do you have with regard to the restraints?
Again, we've already decided that issue. I don't know that there's been any new allegations alleged in the motions by Mr. Owens on behalf of the defendant, but the court has decided that already. And unless there was some sort of change in position or authority, then the court should maintain the law of the case.
Response.
Judge, I just want clarification, but she's here today and she's in handcuffs, so she has difficulty writing. She has.
Let me just interject for 1 second. She will be hands-free.
Okay.
So the issue is the leg restraints.
When
And Judge, she's presumed innocent. I understand security has an obligation. There's 3 doors. I assume we're going to be trying the case in this
Yes, sir.
courtroom. There's 3 doors. I know that we've got several security officers here in case she were to try to flee. But she's got no access to weapons or anything of that nature. She has a fundamental right to a fair trial. She has the fundamental right to a presumption of innocence. And if the jury were to see any restraints on her freedom, they're going to automatically assume the worst, that she is a danger. And people automatically will take that to heart, and it will affect their decision when they go back into the jury room. So, yeah, she's going to be at the table. I don't know if we switch it. Does the prosecutor go over here?
No, that's your table, sir.
That's my table, closest to the jury. So she'll be sitting here with the other 2 lawyers and I. And the only time they're going to see her walk in and out is she's always going to be in the courtroom.
They're never going to see her walk in and out.
So
were you
the
going to
only
say
time is when she
testify?
testifies. So I guess that
She's gonna
only, I don't
testify.
know if you have leg restraints that she can wear and walk, but we believe it's not necessary. And of course, we definitely don't want them to see her walking funny or hear something funny or see something funny. And she's
wants
walking
her
from the defense
to
table
show
to the
off
witness stand
her
to testify on her own
She's
behalf.
milky.
But
white
I don't think it's
legs.
necessary to have
Is
leg
that-
restraints. I think once she gets in here in the trial, beginning
Just saying.
Monday, jury selection,
Just
and
saying.
I assume the tables are going to stay here.
The privacy panels will be located in front as well, which will
Jesus.
prohibit our jury from being able to see
You know
any of the
what?
leg restraints that she has.
I don't think it's necessary to have the leg restraints, Judge. I think you can bring her in with the leg restraints, but take them off right before we get started. I don't see a problem with that. I don't think she's a threat. There are times when criminal defendants are in trial and they misbehave in the middle of the trial, so they have to be restrained. But Sarah Boone, as far as I've been involved, and I think prior to that time, has always been polite and cooperative. And she understands the importance of behaving. And I have every intent that she will comply with the court's directive and she will act appropriately throughout the trial. I do
Right.
not believe any restraints are
Exactly.
necessary during this trial.
Anything further as to that issue?
I don't believe that's case law authority on the issue. I believe.
All right, thank you very much. With
Yeah,
regard
I don't
to
think
your
he's right.
request for clothing in that, you could certainly go to the jail and provide, have whoever it is that you want to meet with her and the meeting area to get measurements from her and provide clothing. The clothing for trial will have to be provided to her at the Orange County Jail. That will be brought over with her in the morning, and then she'll be able to be dressed out downstairs. So your motion will be granted with regard to the clothing. You'll have to address with the jail, having a person come in there to take her measurements. They may have to be with you, counselor, in order to facilitate that. But the clothing will have to be dropped off at the jail. And it will be transported with her in the morning, each day of trial.
Are you telling me that they go and do tailor-made? I sounded like tailor measurements on this woman? Look, Your Honor, I'm a size 12. I'm a medium. I wear a size 8 shoe. I only can dream on those. But you mean to tell me they go and physically say, put your arms up and do tailor measurement? Oh, biatch, please.
With regard to the appearance issue, do you have any other further argument as to that?
Judge, just what's stated in the, I made some legal arguments in the defendant's motion for the right to hair, cosmetics, civilian clothing without restraints for trial. Just the arguments in there.
Yeah, she wants to look like a movie star.
And
celebrity.
The Estelle case that you cited spoke to being dressed out in a prison garb. Doesn't really address a prison guard in shackles. It doesn't address any beautification or anything along those lines.
I just think it's just part of a fair trial.
The other problem is it's contraband. That stuff's not even purchasable at the commissary at the jail, any makeup or anything along those lines.
Well, I'm going to have the two paralegals here. I say the paralegals. One's a lawyer now, and the other is a consultant. But
now you're going to make them be makeup and hairstylists?
They can
That's
bring
not their job.
the cosmetics in and apply it either here in the courtroom or just outside the courtroom. I'm sure there's a waiting room. There's no place where we can apply any.
You can't put them back there because we can't allow access back there. That's for corrections and for the sheriff's department and for the inmates.
I'm sorry.
Can she be allowed?
He has to let the arguments go.
The two females on the team, can they be allowed to apply some type of makeup to Ms. Boone?
Are you kidding me?
We don't have any dog in this fight. I've
I
never
say,
heard of it
I
happening.
ain't touching that woman. Not my
That doesn't mean
job.
It's not permissible, but
If
make
you
it
want
hard
to try to do it
for the
here in the courtroom, that's fine. But be advised that, when we start court, we start court. So, and I intend on starting at 9:00 every morning. So I'll have pleas
8
every
o'clock
morning
my
and
time.
other matters because the court still has other business at 8:45. And I plan on bringing the jury up at 9 until we select one and then starting at 9 every day thereafter. So your motion will be granted with regard to the clothing.
I guarantee
You
she
can
won't have
perhaps
better
someone
makeup than
attend,
me.
Travel to the jail with you, sir, Mr. Owens, to take the measurements. You'll have to provide clothing at the jail. With regard to the appearance, it's denied to have anything happen at the jail or happen in any of the secured areas. But if you want to attempt to have members of your staff apply
I'd
makeup
pay to
prior
have the
trial,
cameras
you
on.
certainly can do so. Court will provide you a written order with regard to the request to removal of the leg restraints. But the hand restraints will be removed. I think that it falls under the same analysis.
It needs to be done in the courtroom.
Yes, sir.
Sorry, baby. Honey boo
Then
boo,
the
everyone's
last
going to see
item
you.
Teed up for today is I'm sorry. Yes. Yes.
Uh-oh. Sheriff's office involved. Because they have to do what the sheriff's office says. The judge will not contradict the control of the client in the sheriff's office.
So corrections
gonna
in
have
the
her
Orange
make
County
it-
Sheriff's Office have just advised me that
She's going to have the makeup removed.
the concern is if makeup is affixed and then she's taken back downstairs and then taken back to the Orange County Jail, they don't know if it's contraband. They don't know what's placed on her person. That's the concern.
There's just going to be some facial makeup.
I understand.
Well, what?
I don't see.
Do you,
What? Whoa. Facial makeup as to what? Private part makeup? Really? Thumbnail makeup? Oh, please. Judge, say no. Say no. I'll pay you a cup of coffee.
See, and sheriff's officer tell me they can't do it because of the
They say no. They say no.
concerns that were just outlined. After she's returned to the Orange County Jail facility.
Wah, 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 wah.
You'll get an order with regard to the restraints no later than
No
tomorrow.
makeup, no hair.
Moving now to the state's request for protective order.
makeup.
I've reviewed that. I need more, I need to understand what you're looking at, Mr. Owens, with regard to these custodians and supervisors at the state attorney's office.
This
I
will be
did not
good.
realize that was going to be addressed today.
Yes, my JA had emailed all y'all, I think last week after it was filed, that said this would be added to the hearing for, I guess that was filed on Monday, forgive me. I had emailed y'all and said that it would be addressed today.
Yep, we got it.
That was relating to me subpoenaing the, and listing the, I think it was
It's the third amended witness list lists certain people as witnesses: custodian of records, Orange County Office of State Attorney, domestic violence supervisor for the Office of the State Attorney, victim advocate supervisor for the Office of the State Attorney, and misdemeanor supervisor for the Office of the State Attorney. And the state is seeking a protective order on the grounds that it's work product or opinion product, and requiring prosecutors to disclose work product and impede criminal prosecutions is violative of Florida
Oh,
law.
honey,
But
boo
as
boo,
you
don't
know,
get your
we
glam
filed our notice of intent for battered
on.
spouse syndrome.
I know, I'm sounding
In
weird.
conjunction with self-defense. And we have listed and plan to introduce the fact that Jorge Torres had been arrested, I think, 3 or 4 times prior to this event. And I think on 3 of those cases, the case was dismissed against Mr. Torres. And it's going to come out that Sarah Boone had requested the charges be dismissed. And I believe it's going to come out probably through expert testimony that that's one of the conditions, or that's one of the things that they try to do, bond you out of jail and then get the charges dismissed as a battered spouse. That's a common theme. So ultimately, the jury is going to hear about that, but the jury needs to know it's the ultimate position. The victim doesn't have the final say. It's the ultimate position from the state attorney's office as to whether to prosecute a case or to drop a case. Yes, they are to consider what the victim wants, and they are to consider their request, but ultimately, the state attorney has to make that decision about whether a case is dismissed.
What are you going to be asking from these persons?
That,
How would that not be protected by work product?
well,
to whether
if
or not it was
if
a
it comes
decision.
out, if it comes out that she went down there and requested the charges be dropped and they were dropped, then that gives the impression that she had the power and authority just to come down to the state attorney and ask the charge to be dropped, and they would. When in fact, the ultimate call is the state attorney's office. They don't have to drop cases, even if a victim claims they do. So just that decision by the state attorney to drop it was their decision. They considered the victims, but it was their decision to drop it and their power and authority to do so, not the victim's authority.
Okay. Response?
Judge, that's opinion work product. That is absolutely protected. I don't understand why he believes that arrests and dismissals are relevant. What is relevant in a self-defense case is if the defendant is aware of specific instances of violence that the victim has committed, or reputation evidence that can come in from anybody, and it does not matter whether the defendant's aware of it. The notion that this sort of evidence would be admissible, much less through the vessel of sworn prosecutors, and they have now gone ahead and named people who aren't even involved with the cases. Matthew Storch, Christina Mills, and Aaron McCullough, our head victim advocate, have all now, I learned while we were at the jail this afternoon, been served with subpoenas by the defense, and we are moving to quash those. Prosecutors and victim advocates and other support staff cannot be forced to come in and say why they dropped a case. That is opinion work product. And if they want to get public records
about these cases and try to get them moved into evidence, then they have to do public records requests or compel discovery from the state attorney's office, which I believe we all have. The state has just been dropped with her medical records that Investigator Lane got in 2021, even though they keep on saying in their amended discovery exhibits that they don't even have this evidence. We got dropped last Friday, the Aspire records and the Advent Health records that have documentation that Billy Lane picked them up in 2021. So the defendants had these things that are getting dropped on the state for years, and we're just getting dropped on us this Friday. And now we are having to combat subpoenas and requests for documents. It is opinion work product. The people that they have listed didn't handle those cases or make those decisions, but that is the ultimate protection, is why we drop these cases. And it's up to the defendant if she wants to come in and say, yeah, I asked to get these cases dropped. I mean, that evidence is coming in anyways through her phone extraction. She is immediately working to bail the victim out. She's immediately working on dropping charges. In fact, there's a video of her coaching the victim on how to drop charges against her on her phone. So all that evidence is going to come in, but it can't be coming in through opinion work product of the assistant state attorneys and our support staff.
Any further argument?
I didn't make the argument.
I did not make the argument that the state attorney was going to be called to ask why they dropped it, as he just referred to, where they had to explain why the case was dismissed. No, the reason for that is just to explain that they have the ultimate power to dismiss, not the victim in a case. Not why we chose to drop 3 cases against Jorge Torres, but they have the ultimate authority. The victim does not control the case. The state attorney does.
Sir, you are a phenomenal attorney
You have a
in
written
the
order
sense
on
that
the
you
motion
are
to protect
doing your
orders for
job, but you're
tomorrow, as by
irritating
tomorrow
the
as well.
living
Anything
hell out
else,
of me.
state, we need to address?
Oh,
It appears, and again, been conducting motions all afternoon, it appears that we are set to allow the defense to depose our battered spouse syndrome expert at 10 a.m. tomorrow. Yeah. And that will be done virtually.
With regard to the deposition of Dr. Brannon, the deadline is tomorrow.
That's set at 3 p.m.
Okay, that's still set at 3 p.m.
Yes, there will likely be a pending motion to strike if his testimony is duplicative with Dr. Harper's. My understanding from the defense is he's just going to explain what battered spouse syndrome is. It's unclear why or how that would be different than Dr. Harper explaining that.
Is that taking place here, or is that taking place in South Florida? Virtually?
Unfortunately, due to time constraints, I cannot be everywhere at all times.
Okay. All right.
really? Oh,
Dr. Brannon's deposition, yes, it's set for 3. I'm just learning now that the expert is going to be available at 10. All's expert by Zoom. And we did talk about that at the jail, trying to schedule something for tomorrow. So she just evaluated Sarah Boone from noon to 2, and then I'm going to take her deposition at 10 tomorrow morning by Zoom. And then
the depositions have not happened.
if they file some type of motion about that, then of course I'm going to respond. We're going to need to have a hearing on it. So,
If go ahead, I'm sorry.
those 2 things are the only 2 things that I believe we have left prior to jury selection on Monday.
Okay. If any motions are
What? Oh, man. That sucks. That sucks. Okay. They cut us off. All righty then. Okie dokie. We done on that end. I'm going to see if they come back live. I want to see what happened. What happened? What happened? What? Okay, tonight, Trial TV Live is going to be again with Jules and Dr. Rachel. Oh my God, that's going to be awesome. I'll be on next week, next month. People are saying the hearing is nuts and off the chain. Okay, guys. Wow. What are your thoughts? Oh, Amos, yeah, I feel 50 years after. Yep. I was like, what's happened? It just went, whoop. That was it. Okay, dokie. We're going to do this. All right, guys. That was interesting. Very interesting, said the putty cat. So let me say so long, farewell. I hate to say goodbye. I'm relieved that she's not going to get makeup and hair. I was kind of wondering about that because she can't go back to the jail with the makeup on. And one of the policies is that people have put makeup on and laced the powder with another powder and put it on the face and go back to the jail and do this and lick it off and get high. So that's an issue. So they just don't do it. So I was like so happy when I saw that sheriff going up because my concern was not so much that she had the makeup put on, but the fact that when she goes back, it has to be completely off. Oh, the female inmates would go ape nuts if she had makeup on for the rest of the day for the month of trials or however long it is. Every day she comes back and she's all glam and they can't. So I'm good with her not being in makeup and hair. Yay. Interesting to see what kind of clothing she wears. They will have really it's a calf. I call it a calf anklet. And it will shock her like a taser. Yeah, but guys, as much as we're getting irritated with him, he's doing a good job. He's doing his job. Just the way it is. He's walked in and threw everything he could think of at the door and see what would stick. I respect him for taking it on so vigorously versus if he just kind of walked in and went, yeah, okay, like whatever. No, I would want him on my side if I was in her shoes. Doesn't mean that we have to be happy about everything he does. Okay, beloveds, I came in this morning thinking I was going to get homework done. We're going to have this little hearing and be done. Didn't work out that way. So I'm going to say farewell. I will be back here to watch the Jewels and Trial TV Live. But in order to do that, I got to get some stuff done. So with that, I'm going to say farewell. I bless you. I thank you. Be kind to people who are having a bad day. And remember, if you're here today, it's a good day. Always the alternative. Bye, guys.